Layman's Lawyer is provided by the Georgia Civil Justice Foundation. The foundation publishes a free quarterly newsletter to teach you about our legal system. The foundation's telephone number is 404-522-2744.
Hi, I'm Dennis O'Hare. Happy holidays and welcome to another edition of the Layman's Lawyer. We hear a lot about how clogged our legal system is getting and how expensive it is to take our fights with one another into court these days. Well, in the last couple of decades, people have been looking for alternatives to court trials in civil cases, and they found them in mediation and arbitration. It could be a divorce or a child custody fight or a negligence case or a business battle. Any of those could end up in what's called alternative dispute resolution. If you want to know how it works, just give us a call at 404-815-3030. We've got attorneys here to take your questions, and we'll hear from some of you live in just a bit. Joining us tonight, Pat Suta of Resolution Resources Corporation. Pat is a mediator and an arbitrator, and Randy Kessler of the law offices of Randall M. Kessler. Welcome to both of you. Nice to have you. Hope the holidays aren't running away with you. But,
thanks for having us.
Good to have you.
Nice to be here.
Ms. Suta, let's start with you. When you are talking about mediation and arbitration, you're talking really about two different things.
That's right.
What exactly is arbitration? Since you're both, we'll start with arbitration. What's that?
Arbitration is very similar to a trial in that you have a person, a neutral person, the arbitrator, who will listen to evidence and argument from both parties and then make a decision.
So you're kind of like a judge in that sense?
Yes.
Okay. Now, a mediator does what?
A mediator is also a neutral person, but the mediator will not be making a decision. The decision will be in the control of the parties. The mediator assists the parties in their negotiations and helps them reach a resolution.
Okay, it's kind of like a catalyst, really, as opposed to the person actively doing the decision.
That's right. If the parties are not happy with the options that are being discussed, there will be no resolution.
They can get up and walk out.
They can.
We see it in labor negotiations all the time. Maybe that's the best way to look at it, the difference between the two. Sometimes you'll hear of a dispute between, say, union and management. It'll start with mediation. Somebody will get mad, walk off in a huff, and then somebody will order them into binding arbitration. Then they get in there and the doors close and they're stuck. Is that pretty much how it works?
In terms of mediation, it's got an excellent resolution rate, about 80 to 90% for people who come voluntarily to mediation. But there will be cases that don't resolve, and so if you don't have a resolution in mediation, you can go on to another process like arbitration or a trial.
Mr. Kessler, are there some cases that more naturally lend themselves to one or the other?
I think, without a doubt, the more interpersonal cases, the people that have personal issues aside from just dollars and cents, where a mediator can really get into what the issues are behind what seems to be the issue. If it's a divorce case, for instance, does somebody really want custody, or do they just want to be a co-parent and have a part in the child's life? As Pat was saying, there's a difference between arbitration and mediation. I like to use the word facilitator instead of mediator, because a facilitator is somebody who helps the parties do it themselves, and the parties can get up and walk out if they want to. But the mediator, a good mediator, will facilitate a settlement on either all the issues or at least part of the issues.
You know, that's interesting. You said on at least part of the issues. A lot of people think, well, we've got to take our whole problem to mediation or arbitration if that's the way we want to go. It doesn't have to be that way. Mediation can be part of a larger process, can't it?
Agreed. I think the only real requirement for mediation is that you come with an open mind. Judges will say you must attend and have good faith discussions. But as long as you start trying to discuss everything and keep your mind open, if you make positive progress, you can settle part of the case, all of the case, or none of the case, but know that if you come back in a month, you may be able to resolve some issues after you see how much money the other side actually has in the bank or what the documents really say.
And actually, in some cases, you know, mediation can only be part of it. If it's a divorce case like you were talking about, or a child custody case, ultimately that has to be decided in court, right, with a decree or with a decision.
Right.
So you're going back to court eventually anyway, even though you might not be fighting anymore.
Right. Even if in a mediation, if you settle everything and you sign an agreement, technically under Georgia law, you have to ask the court to authorize and adopt those findings. For instance, if somebody wants to give their soon-to-be ex-wife a Porsche and say, if I give you a Porsche, I don't have to pay child support, the court reserves the right to stick its nose in and say, that's not a good agreement, I'm not going to validate that agreement. But other than that, if you run it by the court will usually rubber stamp it if it's been a real good faith mediation.
Ms. Suda, are there advantages or disadvantages to both? If you're saying you're in the middle of a fight and you say, all right, we don't want to go to court, you're trying to decide which way to go. Are there pros and cons of each?
Yes. Both mediation and arbitration are less expensive and quicker than going to court. But mediation really is a much better process if you're trying to preserve relationships, because mediation is not the same type of process. It's not an adversarial process like arbitration or going to trial. So that has advantages not only for divorce cases, but cases where you want to preserve the relationship. It may be an employment case if you've got a dispute with your employer, or if you have a business case and you're anticipating continuing to work with the business partners in the future. That would be another case. So that is a real advantage.
Now, how about arbitration? What are some of the advantages there? I mean, you may not be coming out of it with any relationship at all, but you're coming out with something anyway.
Right. Well, with arbitration, you do have a person who's going to be making a decision, and so besides it being cheaper and also quicker, you get to pick the person who's going to make the decision in your case. When you go to trial, you don't get the chance to pick your judge. So that's an advantage. Many people like having that opportunity.
All right, well, we've already got some calls. Let's go to Dunwoody. Hi, you're on the Layman's Lawyer. Go ahead.
Thanks for taking my call.
Thanks for calling.
I'm currently involved in a civil action. I am the defendant, and both parties have engaged attorneys. I'd like to know, is it possible that I can circumvent the court process and go to arbitration? And if so, how can I actually go about the steps involved of getting to arbitration? Do I need a lawyer to do that?
Okay. Actually, that was going to be my next question. So, Ms. Suda, let's start with you since you're the arbitrator here.
If the case is already in court, this person would need to have the agreement frequently of the other party that they would like to arbitrate.
Let me back up just a second, because he said he wants to go to arbitration. He didn't really indicate whether the other person in the dispute wants to or not.
That's right.
Do you have to have both parties agreed, or can you go ahead and say to the judge, hey, I want to go to arbitration, make him go to arbitration too?
You can ask the judge to order the parties to arbitration, but if it's court-ordered arbitration, it has to be non-binding arbitration. But you can, in some circumstances, go to arbitration even if the other party does not currently want to. Sometimes there are pre-dispute contract clauses. So if the parties had agreed previously, if a dispute came up, they would go to arbitration. Then one party can enforce the arbitration.
You see that a lot in employment contracts, for instance.
That's right.
Yeah. Okay, now, he also wanted to know if he needs a lawyer if he goes to arbitration.
It's not mandatory, but it certainly is a good idea, because especially if you're going to be doing binding arbitration, your appeal rights will be very, very limited once an arbitrator makes a decision. And you will have to be presenting your evidence and your arguments, so it can be very helpful for a lawyer to assist with that process.
Now, what is, before we pick up on the attorneys again for just a moment, I want to go back, because we mentioned binding and non-binding a couple of times here. When do you see binding arbitration, and is there a difference between the two? Obviously there is, but what is the nature of the difference between the two?
If you have binding arbitration, the parties are essentially agreeing that they will be bound by the decision that the arbitrator makes.
But this can only come with the agreement of both parties, right?
Yes.
Even the court can't impose it.
Well, there can be a contract that the parties have entered into, or some employment agreements have in binding arbitration clauses. But if a court orders arbitration, it has to be non-binding.
Because you're not giving up any of your rights without your saying, I give this up.
Right.
As a taxpayer, you have the right to go to court and to have the judge of your county decide your case. Also, if I might comment on the non-binding arbitration, My view of non-binding arbitration is really a reality check. If people go through, present their evidence in a shorter fashion, a more economic fashion, where they don't have to spend thousands of dollars on lawyers going to court because they know there's always this other way to get around it to go forward to court. They present their case to a neutral arbitrator, and the arbitrator says, you are not entitled to money. Well, that person's going to know maybe it's not worth spending money going to court, or vice versa. If the arbitrator says you're entitled to every penny you're seeking, then maybe the other side will realize, maybe I should offer a settlement, maybe I should pay 75% instead of paying a lawyer. So a reality check is a good substitute word for non-binding arbitration.
That's right. Many cases do settle after that decision from the arbitrator, even when it's non-binding.
You know, who is an arbitrator and who is a mediator? You're both. Ms. Sudo, again, we'll start with you. Do you have to be an attorney to be an arbitrator?
No, you don't. In fact, arbitration was originally started to allow people to get out of the court system. So people have used arbitration in the past frequently because they want people who have different sorts of training. For example, in a construction case, sometimes people want to have the person who is the decision maker to be someone who has expertise in construction.
Yep.
So there are many lawyers who are arbitrators and mediators, but you do not need to be.
Okay. And actually, that raises the next question, which is, do you have to know about what the dispute is about? You mentioned a construction case. They may say, well, it's more important that the person know about construction than that the arbitrator be an attorney. Does the arbitrator even have to know, or even a mediator have to know about the area in which the dispute is, or is it more important that they know how to resolve disputes, whatever it happens to be?
I think if the lawyers are involved in the case, the lawyer has to analyze each situation and say, this case requires a psychologist because the person is very emotionally tender, or this person needs a reality check from a divorce lawyer who's been to court on the same kind of issues, so that person can step back and say, Mr. Kessler, your client is asking for too much money, and I've been to court, and I know that. And again, there's a fine line between offering advice and telling what they know based on their own experience, but sometimes we seek people that know that kind of law, particularly so they can tell both parties, you know, here are the parameters of reasonableness.
Duluth, hi, you're on the Layman's Lawyer. Go ahead.
Yes, I'm currently getting ready to go through arbitration, and I'm curious to know that if Georgia offers punitive damages when you do go through arbitration.
Oh, is this binding arbitration? Where
Yes, it is. It's through a real estate contractor. We bought our home a couple of years ago, and we're both going to arbitration now.
Real quickly before we get to your main question, was arbitration part of the contract that you had with that builder?
Yes, it was.
Yeah.
Binding arbitration.
Okay, so when folks read contracts, make sure you understand that that's often part of it. Okay, punitive damages. Is that?
That's going to depend.
Nice lawyerly answer there.
Because often the remedies that are going to be available and what the arbitrator can do, often that's going to be controlled by the arbitration contract.
But of course, a lot of times the arbitration contract may say they're allowed to do whatever is allowable under Georgia law. You're substituting an arbitrator in for a judge or a jury, so it may depend on whether punitive damages could have been obtained had that case gone to court instead of to arbitration.
So, but his question was, does Georgia law allow punitive damages in general? That was part of it. I mean, you can have punitive damages come out of arbitration, but in his case, it might depend, number one, on what the contract says, and number two, on whether punitive damages normally are part of a case like that that goes to court.
Right, and it might depend more on the facts of his particular case as to whether he should get punitive damages.
But the basic answer to your question is, yeah, it's possible, it just depends. Does that help you?
Well, it does. I'm just curious because also in a standard real estate contract, it states that, you know, they don't knowingly bury garbage, and that's what we're going to arbitration for, was I had a garbage bin put in my backyard. So this person actually committed fraud. And so, but we're going to arbitration, and that's why I'm kind of asking on the punitive damage part, and I kind of heard from the gentleman there that if it would have gone to court, that it might be possible for an arbitrator to make that type of ruling as far as punitive damages, you know, and actual damages suffered also.
Again, it's hard to say what your case would do without taking a look at a lot more than we can right here. But Mr. Kessler, again, it just depends on how things would have gone in a similar case in court.
If his contract for arbitration isn't limited, if it doesn't say these are the only remedies you can pursue in arbitration, then the likelihood is that he would be allowed the same remedies that he would have been able to achieve in court. And again, I'm not a real estate expert, but a real estate lawyer could probably advise him what he could get in court, and he probably has the same remedies available to him in the arbitration.
Good luck with that.
Thank you.
Thanks for the call.
Uh-huh.
Let's take a look at the process now. Starting with mediation, Mr. Kessler, we've talked a little bit about what it is. It's just listening, really. But is there a formal mediation kind of ritual that you go through?
There is. Generally, the mediator will introduce themselves, put everyone at ease, make sure everybody knows that you can get up and walk out if you don't like the way it's going. It's a voluntary process. And there's sometimes forms. It depends on the court you're in. If you're in Cobb County, there are certain forms that you sign to, you agree that you cannot subpoena the mediator to say, in mediation, my wife said she only needed $200 a month. But other than that, each mediator has their own way of handling the cases, and it depends on the facts of the case. Some options are to meet with the parties alone without the lawyer.
Yeah, you don't even have to be in the same room, do you?
You don't have to be in the same room. You can meet with one party by themselves, with a party and their lawyer, and you can caucus. They call that caucusing, so that you can really air your grievances without offending the other side, so that everybody's just throwing words across the table. It really helps you get to the nitty-gritty.
So a lot of the structure is left to the mediator. It's not as rigid at all as a court proceeding, for instance.
Exactly. And I think the beauty of mediation is that it really lets the mediator listen to what's at issue. What are the real concerns of a party? I had a case a few weeks ago where there were two individuals going through a divorce, and they both earned significant incomes. So either one could have supported the child on their own if they had to. And the issue was the wife wanted to protect herself in case she lost her job. Mm-hmm. She wanted to make sure she had enough money to pay for the child. And the husband wanted to make sure the child had private school paid for. So what we did is we agreed the husband would pay a little bit more child support, and the wife agreed she would be responsible for paying for private school. It met everybody's concern. The husband was happy because the money was going to be going for the child. The wife was happy because she got enough money to make herself feel comfortable. And we really got to the bottom of it. Whereas in court, you present your concerns, and the judge says, this is it, and that's it. And you can't go back and
Sometimes
say...
neither side wins.
Exactly.
Yeah, and especially if there are children involved, they definitely lose. But let's take a look then at what you can do. You mentioned before, very often the mediator will tell folks, you can walk out if you need to. But suppose you've been ordered into mediation, and we're seeing that more in a lot of jurisdictions. Cobb County is one where a lot of civil cases are ordered, boom, you've got to go to mediation before you even go before a judge. Suppose you're in that situation and you want to leave. Do you have to get the judge's permission and say, you know, now I want to go to court, or is just notifying the judge enough?
Well, in terms of court-ordered mediation, if you really believe that your case is not an appropriate one for mediation for some reason, you can request that your case be excused from mediation. So that would be the process if you don't even want to begin.
Okay.
But
suppose you're in anyway and it's not working, or you think it's not working, or you just don't want to be there.
You can leave. There's no problem. Although you're ordered to try mediation, you're not ordered to try to come to any particular resolution, so you don't need to stay for any particular period of time. The court asks you to try to negotiate a resolution in good faith, but if you are not able to, that's not a problem. That's not a problem. You're not required to stay for any particular length of time. It is a voluntary process. What I find, though, I do both private mediation as well as court-ordered mediation. Even if people really were reluctant to come, did not want to come, once they're there, once they learn the advantages of mediation and see how it can really benefit them, they're eager to stay and to work on a resolution.
Perhaps the best part of mediation is just getting the people in the door. I see as a lawyer, honestly, I see as a lawyer, part of the biggest difficulty in solving a case is communication. If the other lawyer sends me an offer, I send it to my client to look at, the client writes on it, sends it back, I have to send it to the other lawyer, they send it to their client. If we're all in the same room at a mediation, we can do that in 15 seconds.
Yeah.
And just having the ability to communicate, consider, and respond all within a short time period makes a lot of headway and a lot of progress in difficult cases.
Let me ask you something, though, that I'm sure comes up in a lot of mediation. You're at a point where maybe you're pretty close to what you think is going to be the deal that will work. One side is going for it, the other side isn't. And you're the mediator, and let's say, Ms. Sudes, in your case, you're an attorney as well. You're going to the reluctant party and you're saying, this is really as good a deal as you can get. Now, is there a line there where you can't cross, where you cross the line from being the mediator to giving that person legal advice?
Right.
Yeah, is that a blurry line there?
Well, the mediator certainly cannot give legal advice. Even if you're a lawyer, you cannot give legal advice. There are really two different types of mediation, though. We've got facilitative evaluation, and then we also have evaluative mediation, where the mediator actually can give an opinion. And sometimes that's what the parties are looking for. They want to pick a mediator who has some expertise in the subject matter of their dispute, and they are interested in having the mediator at some point, if they're not able to come to a resolution, giving an opinion.
And you brought up an interesting point. If you're close, the temptation is always to say, let's cut it right down the middle.
Right.
And there's a downside to mediation, which is a mediator's job is to facilitate a settlement and bring closure. And the times when mediation can be problemsome or troublesome is when a party is being fair and the other side is being unreasonable.
Yeah, because you could end up with less than you would have gotten in court.
Right. Somebody being reasonable might say, I want $500, and the unreasonable person might say, I want $2,000, and the mediator, being a mediator, trying to facilitate closure and settlement, says, let's split the difference, and that's really not fair to the person who starts off being more reasonable. So you really have to get into, what is fair and who has really been fair, as opposed to just saying, hey, the easy way out is cutting it right down the middle.
I think on that point, it's important to remember that one of the important jobs of the mediator is to do some reality testing with the parties, to ask them questions, to help them re-examine their assumptions, to point out the strengths and weaknesses of their case. So in that particular case, if you've got someone who's taking an unreasonable position, the mediator's job is to try to enlighten through the questioning process to help the party come to see that. And also the mediator doesn't have any power to force someone to be making, to be accepting anything. So if a party feels that it would be unfair, they don't have to agree to it.
We're already real short of time. I wanted to get from that to arbitration, but before we do, once you've reached a deal, you sign it, and is it treated as a contract or just any other legal agreement? And very often, as you pointed out, we have to, if it's a family law case, you got to go back to court and get an order that incorporates your agreement.
And again, you hate to give the standard lawyer answer, it depends, but different courts have different forms. Fulton County, for instance, has a form that differs whether you go with lawyers or without lawyers. And generally, if you go without your lawyer, but you're represented, there's a grace period. You usually have 5 days or 10 days or a week to run it by your lawyer to make sure you didn't miss any legally relevant points.
Yeah.
But once you have it all signed and sealed, if you're in the middle of litigation, you have to do something further. You have to get it authorized by the court or signed by the judge so that it becomes a judgment, which then is enforceable as if you had gone to trial and obtained a verdict.
In just a couple of minutes here, Ms. Suda, let's take a look at arbitration. We mentioned before, it's a little bit more like a trial, and the arbitrator is more like a judge. Are the rules of evidence the same, though, and the questioning of witnesses, cross-examining, that kind of thing? Are they pretty much the same as in a regular trial?
Rules of evidence are relaxed, generally, so you don't have the following the strict rules of evidence. You are doing the examination of witnesses, though, much as you would in court, so a direct exam and a cross-examination.
Then does the arbitrator make rulings about things that are admissible and things that aren't, all that kind of thing? All right, suppose you don't like what that arbitrator decided and you think that was a key ruling in your case. Can you appeal that like you would, a judge's decision? Generally
not. And unless you have something specifically in your agreement to arbitrate, the ability to appeal an arbitrator's decisions is very limited. So if the arbitrator makes a mistake of law, that is generally not going to be a ground to appeal the arbitrator's decision. Okay, and it's important, I think, to say here once again, if it's binding arbitration, both sides have agreed to it in some fashion sometime prior. So you knew what you were getting into, like when you signed that labor agreement or when you got together in the dispute and said, we'll go to binding arbitration.
But you have to be very careful about the language because obviously you're giving up a lot of rights. The right to a trial by jury is a very important right. And unless your document is absolutely specific that you're giving up that right, you may just be opening a can of worms because somebody might get a result they don't like and say, I'm not bound to this. And they may not be bound to that. If the contract or the agreement to arbitrate is not solid.
And it's different, though, if it's non-binding arbitration, obviously. You can go to court on that and appeal it, right?
That's right. If it's non-binding arbitration, you haven't given up your right to a trial. Right. Binding arbitration, you are using the arbitration process instead of a trial, so that you don't have the opportunity to go to trial then.
Okay, what happens if you are in the middle of a dispute? You've won, you're going to get your money, you think, Mr. Kessler, and is there any way to enforce a mediated agreement or an arbitrator's decision that's any different than, say, if you had gotten a real live big ruling from a court?
There may be more litigation about that issue than any other issue, at least in domestic relations or person-to-person type litigation. What you're really talking about is a motion to enforce a settlement agreement. Mm-hmm. An agreement reached at mediation is the same as a promise between people. You're just trying to enforce it. The benefit of mediation is that they do have all the forms. You can write a memorandum of understanding so that everybody is clear what they agreed to. Once they agree to it, the court should authorize it and enforce it and make it into a court order. Once that's done, you can go.
It's the same as any other court order.
Correct. You have the same remedies, contempt in a divorce case or FIFE, garnishment for collection of monies.
Okay. Thanks to both of you for being with us on this edition of The Layman's Lawyer. Next week, right before New Year's Eve, what else? DUI. We'll see you then.
Major funding for The Layman's Lawyer is provided by the Georgia Civil Justice Foundation. The foundation publishes a free quarterly newsletter to teach you about our legal system. The foundation's telephone number is 404-522-2744. WPBA is not licensed to practice law or provide legal advice in Georgia. WPBA and the Georgia Civil Justice Foundation are not responsible for the views expressed or the information provided by lawyers on this program or on the telephone. This program is offered as a public service, and in all legal matters, you are best served by retaining your own attorney for private legal counseling. The lawyers appearing on this program and answering telephone calls are attempting to give general information on how to approach legal problems. Each advises viewers and callers to consult with an attorney of their choosing at a time when all facts may be fully disclosed, rather than by acting on the general information given in a brief phone conversation. Also, by taking your call, none of the lawyers agrees to represent you with your particular problem.
For holiday entertaining, the Metropolitan Museum of Art's shop at Lenox Square sparkles with seasonal pieces infused with designs from centuries past. Plates with golden leaves from China's Qianlong period, striking ornaments from Murano and London, and brilliantly festive Italian cut glass bowls glisten under the lights. Necklaces with ancient Greek designs are enhanced by poinsettia grass from Prague. All proceeds from sales go to the Metropolitan Museum of Art, sponsors of this message.
Enter the world of National Geographic and one of the Earth's most formidable deserts. Rare and elusive elephants lured this adventurous team to the challenge.
Child on the run, and their mother was put in jail for refusing to tell the little girl's father where she was. But tonight, JD and her mother are together again and free from the fear that forced them apart. Keith Whitney has more on this exclusive story. Keith?
Well, Brenda, the story goes back 2 years to when we first told you about Jade and her mom, who were on the run together. Then her mom was struck with diabetes, and the little girl had to take flight without her. But tonight, that's all in the past. It was a moral conviction, not a legal one, that sent Tess Kittle to jail back in September.
Love you.
Kittle said her daughter was in danger from her father. And while 8-year-old Jade was on the run in the child underground, Kittle spent 50 days in isolation.
And it was 50 hard days on her because of her diabetes. They let her go into shock more than once.
But then came the shock of her life. A judge let her out on bond and agreed to reunite her with her daughter. And today, on a sunlit, tree-lined street in downtown Atlanta, Tess Kittle and little Jade emerged together from the underground.
Yeah, she's got an accent, and she has more teeth than when she left.
What are you guys going to do now?
I don't know. Probably just be together.
Jade spent much of her time in this safe house.
She lived
on 10 acres up in a mountainside in a small community in Oregon. She went to school. She played soccer.
At her goodbye party, she was joined by other children who are also on the run. The man in the middle is Al Dietrich, a news photographer from Pittsburgh, who's covered these kids for a year.
I've shed more tears over this story, and I don't see how you could do a story like this and not care about it.
At least one of Jade's surrogate moms still faces possible arrest.
It's worth it. You can never put a value on a little girl's safety.
Kittle is satisfied that the judge finally heard her plea.
He turned around and gave her every possible protection. It's probably the strongest, most protective visitation arrangement that I've ever seen.
Now, not only did Jade's adopted families embrace her, so did the entire community in that section of Oregon. Everyone there knew she was on the run, Brenda.
So, Keith, what are the terms of visitation for her father?
Well, remember, though indicted, Kenny Ellis was acquitted of molesting Jade, but he will only get to see her for an hour at a time, supervised at DFACS.
All right, Keith, thank you very much.
Atlanta's bomb task force laid out its cards and much of the evidence on the table today. Components of devices from 3 Atlanta bombings show us why investigators think the bombings are the work of the same terrorist or terrorists. And as 11 Alive News reporter Kevin Rosen tells us, those components also explain why investigators feel they may have had contact with the bomber through a letter.
Imagine how Atlanta bomb task force members must have felt when they got hold of this letter back in February.
This young orangutan, named Karen, was born with a hole in her heart. She's about to undergo an operation to save her life. The surgery is taking place at the San Diego Zoo, and the patient is prepared under strict hospital guidelines. Today, Karen will undergo open-heart surgery. This operation, one of the first of its kind, is drawing media attention. Karen has had a tough life so far. Her mother was unable to care for her, so she was taken out of the group to be hand-raised. Because of her heart condition, she was sick and underweight.
Let's move her record, too.
At only 2 years old, she faces the risk of a fatal heart attack. But hopefully, today's surgery will send her on the road to a healthier life. Most of the doctors had never worked on an animal before, but the bodies of apes and humans have a great deal in common. In fact, our hearts are virtually identical. Once the incision is made, the